In the autumn of 1883, Yavapai County, Arizona Territory held more unclaimed desert acreage than it held people, and the land office in Prescott was working through a backlog of disputed claims that stretched back 4 years. Cole Harlan stood at the window of the Prescott land office on a Tuesday morning in October, reading the glass rather than looking through it. The reflection showed him a room, 12 feet of pine counter, 2 clerks with ink-stained fingers, a territorial seal painted directly on the plaster wall, and in one of the 2 chairs that the office kept for visitors, a woman who had been sitting with the same piece of paper in her hands for going on 40 minutes. She had not been reading it. She had been holding it the way a person holds something they are afraid to set down because setting it down means it becomes real. Harlan was not in Prescott on her account. He was in Prescott because the territorial judge had summoned him about a different matter entirely, a cattle theft dispute running between 2 ranchers in the Verde Valley that had begun with a missing bull and was threatening to end with a shooting. Harlan had ridden up from his jurisdiction in the Tonto Basin 2 days along the Agua Fria Road, arriving the evening before. He had no appointment until 11 o'clock. It was 9:47 by the clock on the wall. He turned from the window and walked inside. The woman in the chair was perhaps 30 years old, possibly less. Frontier country aged a person at the edges before it aged the center, and Harlan had learned not to trust his first estimate. She wore a dark traveling dress that had seen better road conditions than the one from Wickenburg, her dark hair pulled back under a hat that was too thin for October altitude. Beside her feet sat a single canvas bag, the kind a person carries when they expect to conduct their business and leave, not when they expect to stay. She was not crying, which told Harlan something. She had already done that part. The clerks at the counter were working with the particular efficiency of men who are waiting for a problem to resolve itself. One of them had spoken to her when she arrived. Harlan had seen that exchange through the glass. He had seen the clerk gesture toward the chair, say something, and return to his ledger. The woman had sat. The problem had not resolved itself. Harlan moved past the counter to the second clerk, a young man named Tully who handled survey records. "That woman," Harlan said, keeping his voice low. "What is she here for?" Tully glanced at her and then back at Harlan's badge, which was pinned under his coat lapel, and not visible unless a person looked. Tully looked. "Deed dispute," Tully said. "Desert homestead claim out toward Skull Valley. Says she's the widow." "Who filed the original claim?" Tully opened his mouth and then closed it. "That's the part, Marshal. The man who filed the claim. She says she never met him." Harlan said nothing for a moment. "She's saying her husband filed a land claim and she never met the man she married. She's saying she was the one who found the land," Tully said. "Walked it herself, surveyed it herself, paid for the entry herself. But when the papers came back from the recorder's office in Prescott, the deed was made out in her husband's name, Reuben Voss. She says she is not Reuben Voss, that she has never been Reuben Voss, that she has no husband, and that she would very much like to speak to someone who can explain how his name came to be on her property." Harlan looked at the woman again. She was watching him now. She had heard enough of the exchange to know he was asking about her. "Who's Reuben Voss?" Harlan said. Tully lowered his voice another notch. "That's the second part, Marshal. Reuben Voss is Delia Voss's deceased brother-in-law. The woman in the chair was named Delia Voss, and she had come 312 miles to find out why a dead man owned her land. Delia Constance Voss had been born in Galveston, Texas in the year 1856, the second daughter of a shipwright named Arthur Meader who worked the Gulf repair yards and a woman named Clara who kept a boarding house on the Strand. The Meader household was not prosperous and not destitute. It existed in that particular middle distance that most working families in a port city occupy, where a good month means full plates, and a bad month means calculating what can be stretched. Delia grew up helping her mother keep accounts for the boarding house, which meant she could read a ledger before she could read a novel, and she understood the relationship between labor and title in a way that many women of her era were not given the opportunity to understand. She left Galveston at 22, not out of unhappiness but out of calculation. The boarding house would pass to her elder sister, who had married a local man with his own claim to it. The repair yards offered her nothing. The Texas frontier was opening in ways that newspapers described with the enthusiastic imprecision of people who had not been there. But Delia had read enough land office circulars, her mother kept them because boarders sometimes left things, to understand the basic mechanics of the Homestead Act and what it offered a single woman willing to work. She spent 2 years in San Antonio, working as a bookkeeper for a freighting company called Aldrich & Sons, saving with the same deliberate patience her mother had applied to the boarding house accounts. She was not saving for comfort, she was saving for a stake. In 1880, with $411 in a bank draft and a letter of introduction from her employer to a land agent in Prescott, she boarded the Southern Pacific at El Paso and headed west into the Territory. Arizona Territory in 1880 was in the early stage of what would eventually become a systematic economic organization, but in that year it remained a place where the infrastructure of civilization arrived in pieces that did not yet connect. Prescott was the territorial capital, a real town with brick buildings and a proper bank and a newspaper that had been publishing since 1864. Outside of Prescott, things became more provisional. The stage roads were rough. Water sources were widely spaced. The land was not hostile in the way that myth described it. It did not actively hunt a person, but it was entirely indifferent to human plans, and that indifference was its own kind of difficulty. Delia Voss arrived in Prescott in the autumn of 1880 and spent 3 months working for the same freight operation that had given her the letter, operating their books while she used her evenings to research available land. She was looking for a specific thing, a parcel with reliable water access, close enough to the Prescott market to make supply practical, large enough to run a small cattle operation if she could acquire the stock. She was not looking for perfection. She was looking for a property that rewarded work at a reasonable ratio. She found it in February of 1881, 14 miles southwest of Prescott, in the open desert country, near a place called Skull Valley. The parcel was 160 acres of high desert, which sounds arid to an ear unfamiliar with the territory, but which in practice meant sparse grassland at an elevation that moderated the summer heat. A reliable seep spring in the northeast corner that fed a shallow draw, and enough cleared ground at the south end that a person with proper tools could break an acre in a season. Other settlers had looked at it and looked away. The water was too modest for a large cattle operation and too far from the road for easy commerce. But Delia was not planning a large operation. She was planning a small one, built carefully, expanded only as the land could support. She filed her homestead claim in March of 1881 at the Prescott Land Office, paid the $14 filing fee from her savings, and recorded herself as the claimant under the Homestead Act of 1862. The act permitted women to file claims, and Delia had researched this specifically before she left San Antonio. She was a single woman, 25 years of age, a citizen of the United States by birth. The clerk who took her filing had looked at her for a moment, and then looked at the paperwork, and then done his job without comment, which she took as a reasonable outcome. She spent that first year living in a canvas structure she erected herself, learning the Seep Springs seasonal behavior, breaking ground at the south end in the way she had planned. She hired labor twice. A Mexican man named Ernesto who worked for 3 weeks building the first permanent structure, a one-room adobe with a proper chimney, and a Yavapai man who agreed to show her the secondary water sources in the surrounding country, which she cataloged and mapped in a notebook she kept with her land documents. She purchased 12 head of cattle in the autumn of 1881 from a rancher named Holbrook who was liquidating part of his herd, paid $47 a head, and ran them on the south grassland through the winter. By the spring of 1882, she was not prospering, but she was not failing, which in the territory was the more important distinction. Her brother-in-law, Reuben Voss, had appeared in her life not through any choice she made, but through the mechanism of family. Her elder sister Marguerite had married a man named Thomas Voss in San Antonio in 1879. Thomas Voss had a younger brother, Reuben, who was 17 at the time and who possessed, by all accounts, the particular combination of charm and unreliability that tends to arrive in younger siblings when the older sibling has consumed the family's supply of practicality. Delia had met Reuben Voss twice, once at the wedding, where he had been the kind of cheerful and handsome young man who made a good impression at a distance, and once the following year, when he had arrived at her San Antonio employer's office, carrying a letter from his brother, asking if she could put him up for a week while he sorted himself out. She had arranged a boarding house room for him, which had been the extent of her hospitality. Reuben Voss had been in San Antonio for 11 days, and then gone, and Delia had given him no further thought. She had been wrong to give him so little thought, as it turned out. In late August of 1882, Delia received a letter at her Skull Valley address forwarded from the Prescott Land Office. The letter was from the Territorial Recorder's Office and was written in the bureaucratic language that government offices use when they are conveying information that would be distressing in plain speech. It informed her that the homestead entry she had filed in March of 1881 had been reviewed and that a discrepancy had been identified in the claimant record. The discrepancy, as the letter explained it across 3 paragraphs of careful phrasing, was this. Under the Homestead Act as administered in Arizona Territory, the entry had been re-examined by the Recorder's Office following a query from the Prescott land agent. The re-examination had determined that Delia Constance Meter, the woman who had filed the claim, was listed in the Yavapai County marriage records as the wife of Reuben Henry Voss, recorded in a proceeding dated November 12, 1879, in Bexar County, Texas. Under the coverture provisions that the Territorial Recorder's Office still applied to real property transactions, the deed to the claim had been re-recorded in the name of the claimant's husband. The deed was now in the name of Reuben Henry Voss. Delia Constance Voss had no husband. She had never had a husband. She had never been married in Bexar County, Texas, or anywhere else. The marriage record was false. She sat with the letter for 1 hour. Then she went to Prescott. The land office clerk who received her had been polite, but genuinely unable to help her. The problem, he explained, was not with the land office. The land office had received the recorder's correction and applied it. The problem was with the marriage record in Bexar County, which would need to be challenged before the recorder's office could be asked to re-correct the deed. To challenge the marriage record in Bexar County, Delia would need to appear in a Bexar County court and produce evidence that the record was fraudulent. Bexar County was in Texas. Delia was in Arizona Territory. The cattle she had purchased could not be left unattended for the months a legal proceeding in San Antonio would require, and she did not have the money to hire a San Antonio attorney to conduct the challenge in her absence. She returned to Skull Valley and wrote letters. She wrote to the recorder's office in Prescott, explaining the situation in full and requesting that they investigate the marriage record's provenance. She received a response, indicating that the recorder's office had no jurisdiction over Texas county records. She wrote to the territorial judge in Prescott, requesting a hearing. She received a response indicating that the judge's docket was full and that the matter appeared to be a civil dispute that would require a licensed attorney. She wrote to the land agent in Prescott whose query had initiated the re-examination in the first place, asking why he had queried her claim at all. She received no response to that letter. The land agent's name was Gilbert Marsh, and Marsh had been operating the Prescott Land Agency for 9 years. He was not a villain in the theatrical sense. He was a man who understood that the desert land market in Yavapai County was changing as ranching operations expanded, and that certain parcels which had been filed under homestead entries by individual claimants occupied positions that would be considerably more valuable to larger operations once the territory's infrastructure developed. He had a particular interest in the Skull Valley parcel because it sat adjacent to a section that a Prescott investor named Alderman Cray had been quietly consolidating for 3 years. Cray wanted the Seep Spring. The spring was on Delia's claim. Marsh's query about the claim had not been random. Reuben Voss, as Delia eventually learned, had died of typhoid fever in Galveston in June of 1882. 2 months before her letter from the recorder's office arrived. He had died without a will and without any property of record, except now he had 160 acres in Skull Valley, Arizona Territory, and because he had died without a will and without heirs other than his brother Thomas, the property might reasonably pass to Thomas Voss, or, more accurately, to whoever presented a legal claim to Thomas Voss's interest in his deceased brother's estate. Marsh knew Thomas Voss through his connection to Alderman Cray. The path from Delia's claim to Cray's consolidated section was 3 legal steps, none of which required a murder or a conspiracy in the dramatic sense. It required only a false marriage record, a dead man's name on a deed, and a woman who could not afford a lawyer. By the autumn of 1883, Delia had spent 14 months trying to correct a record that the territorial apparatus had no immediate incentive to correct. She had spent $62 on correspondence, 2 trips to Prescott, and 1 consultation with a Prescott attorney named Waverly, who had quoted her $225 to prepare the appropriate filings, and told her that even then, resolution might take another year. She had $209 remaining in her bank account. She had 12 head of cattle reduced to 9 by the normal attrition of a small operation in difficult country. She had a crop of winter wheat that she had planted in September at the south end, which would yield something in March if the winter was not too dry. She had a deed in the wrong name and a claim that, as of the previous week, had received a formal notice from the recorder's office in Prescott informing her that the estate of Reuben Henry Voss had been opened in Yavapai County and that a claimant had presented an interest in the parcel. The claimant was a company called the Skull Valley Land and Grazing Company. The principal of that company was Alderman Cray. She had 60 days to respond with documentation supporting her independent claim to the property, or the parcel would be transferred through the estate proceeding. She had 60 days and $209 and a piece of paper that said her land belonged to a man she had never met. She had come back to Prescott to try once more. Cole Harlan had been riding frontier law for 23 years when he stood in that land office on an October morning in 1883. He had come to it the way most men of his background came to it, not because he had planned a career in territorial law, but because the territory needed men who could operate in the country without losing themselves in it, and he happened to be one of those men at a time when that was a valued quality. His mother had been Tonto Apache, from a family that had worked the eastern Tonto Basin for generations. His father had been a Missouri-born freighter named James Harlan, who had come into the territory in 1835, and stayed because the land took hold of a certain kind of man and did not let him go. Cole Harlan had grown up between the 2 worlds that his parents represented, which meant he had grown up fluent in the language of neither one, but capable of communicating across the gap, which was a more useful skill in the territory than full membership in either world would have been. He had worked as a scout for the Army for 6 years beginning in 1859. Operating out of Fort Whipple and later Fort McDowell. He had carried dispatches through country that would have disoriented a man without his particular education, and he had done it reliably enough that when Yavapai County organized its marshal's service in 1872, the first territorial sheriff had come looking for him specifically. He had been a deputy for 4 years and a marshal for 7. He was, by the autumn of 1883, the kind of authority that a territorial system produces when it operates correctly. a man whose office commanded respect, not because of its institutional weight, but because of the accumulation of decisions he had made while wearing it. He was not rich. Marshals in Arizona Territory in 1883 earned $3 a day when working on a case and nothing when not, plus fees for serving papers. He kept a small house in a settlement called Rimrock in the Tonto Basin and lived within what the work produced, which was not much, but was consistent. He did not have ranching money or investor money. What he had was credit. Not financial credit, but the kind that accumulates when a man does what he says he will do in a country where other men have noticed. He had come to Prescott on territorial business, which meant the territory was paying his expenses. He had no personal stake in the land office matter. He had a 45-minute window between his arrival at the office and his 11 o'clock meeting with the judge, and a habit, developed over decades of working the frontier, of paying attention to rooms he walked into. He had noticed the woman in the chair because she was holding a piece of paper the way a person holds a piece of paper when they do not believe anything they do with it will make a difference. He had noticed the clerk's particular efficiency. He had asked one question of the younger clerk which had answered several others. He walked to the chair and stood at a respectful distance from it. "Mrs. Voss," he said. She looked up. "My name is Cole Harlan. I'm the marshal out of Tonto Basin." He showed her the badge. "Tully told me the outline of your situation. If you're willing to go through the full account, I'd like to hear it." She studied him for a moment. She was trying to determine, Harlan recognized, whether his interest was professional or personal or something she had learned to be cautious about. He stood still and let her make the calculation. "It's a land office matter," she said, "not a marshal's matter." "That may be true," Harlan said. "Tell me anyway." She told him. She was efficient about it. She had told it before, to the clerk and the attorney, and in written form to several offices, and repetition had stripped the story down to its essential facts: the original filing, the re-recording, the false marriage record, Marsh's query, Cray's company, the 60-day notice, the $209. Harlan listened without interrupting. When she finished, he asked 3 questions. Was the marriage record a forgery or a clerical error? Had she retained any document from the original filing that predated the re-recording? And what was the exact date of the 60-day notice? The marriage record was a forgery. She had the original filing receipt from 1881 with her name on it as sole claimant. The 60-day notice was dated October 3, 1883, which made the response deadline December 2nd. Today was October 9th. Harlan said nothing for a moment. He was calculating, not hesitating. "Where is the attorney Waverly's office?" he said. 3 blocks north, on Gurley Street," she said. "But I told you he wants $225. "I heard you," Harlan said. He did not explain himself. He asked her to wait. Nobody in that room moved for a full 30 seconds after he turned and walked out the door. The law office of F.P. Waverly occupied the upper floor of a building on Gurley Street that also housed a surveying company and a dentist, and it had the particular smell of all legal offices of its era: old paper, boot leather, and the faint metallic undertone of the ink that the territorial courts required for official filings. Harlan climbed the stairs and knocked, and was admitted by a young man who appeared to be reading a law text under the reasoning that he would eventually understand it. Franklin Waverly was 51, a Virginia man who had come to the territory via New Mexico for reasons he had stopped explaining, because the explanation was complicated. He had been a competent attorney in Virginia, and was a competent attorney in Arizona, and the primary difference between the two practices was that in Arizona, competence in real property law required a thorough familiarity with the intersections of federal homestead law, territorial land law, and whatever county-level procedures had developed in the absence of consistent oversight. Harlan introduced himself and laid out the situation in the same efficient terms Delia had used, adding the facts she had not emphasized. the timing of Reuben Voss's death relative to the recorder's re-examination, the fact that the query from Marsh had preceded the re-recording by approximately 1 week, and the specific nature of the Skull Valley Land and Grazing Company's claim through the estate proceeding. Waverly listened. He asked several questions of the technical variety. Then he sat back. "It's fraud," he said. "Clear as anything I've seen in 9 years of territorial practice. The marriage record is forged. You can establish that from the date alone, since Voss was in Galveston in November of '79, and the record was filed in Bexar County on the same date. That's provable. The original filing receipt she holds predates the re-recording and establishes sole claimancy. Marsh's involvement creates a pattern that a judge would find interesting." "What's the cost to file the challenge?" Harlan said. "The filing fees themselves are $40 for the recorder's correction and another $22 for the estate challenge and probate. My time for preparing the documents, conducting the correspondence with Bexar County to obtain the original registration ledger, and appearing before the recorder, that's where the $225 comes from. If the document preparation is done and the filings are made today," Harlan said, "how long before the recorder acts?" Waverly considered. 3 weeks, assuming the recorder's office is not motivated to delay. 4 if they are. Cray has influence with the recorder. "He does," Waverly said. "Some." Harlan looked at the window for a moment. "I want the documents prepared today," he said. "I want the filings made before the land office closes this afternoon. I want a letter in the judge's hands, Judge Edmonds, who I'm meeting at 11, before noon today, establishing the fraud claim and requesting his attention to the recorder's timeline." Waverly was quiet for a moment. "That is aggressive." "It is," Harlan said. "Her deadline is December 2nd. Cray's people will have someone at the recorder's office within the week to advance the estate proceeding, once they know she's filed a response. We need the correction in the record before that, or at minimum, we need it in motion with the judge's awareness documented." "Marshal," Waverly said carefully, "my fee is $225. I'm not suggesting you pay it yourself, but we should establish who is paying it before I begin." "I'm paying it," Harlan said. Waverly looked at him. "The filing fees as well," Harlan said. $62 for those, $287 total. He reached into his coat and produced a bank draft from the Tonto Basin Merchants Bank, made out as a blank order, which he had drawn 2 days prior, for use in settling the Verde Valley dispute, if it came to that. It had not come to that, as it turned out. The Verde Valley ranchers had agreed on a boundary figure without Harlan's financial involvement. The draft was for $400. He wrote $287 on the face of it, and signed it, and laid it on Waverly's desk. Waverly looked at the draft and then at Harlan. "I'll need her in this office within the hour," Waverly said. "I'll need the original filing receipt and any other documentation she carries." "She'll be here in 20 minutes, Harlan said. He picked up his hat. "The letter to Judge Edmonds needs to be in his hands before 11. He went down the stairs and back to the land office. Delia Voss was still in the chair. She had put the paper down. She picked it up again when he came through the door. Harlan walked to her directly. "Waverly will see you now," he said. "Take everything you have with you. The filing receipt, the recorder's letters, the 60-day notice. He'll prepare the documents today and make the filings before closing. A letter goes to Judge Edmonds this morning establishing the fraud claim." She stared at him. "Marshal, I told you, the fee is $225. "Waverly has his money," Harlan said. "The filing fees are covered. You need to be in his office within the hour." She did not understand what had just happened. She looked at him with the particular expression of a person who has been given something and is trying to determine what the giving will cost. "Why?" she said. Harlan thought about that for a moment. It was not a difficult question. "Because the land is yours," he said. "You filed the claim, You built the structure. You bought the cattle. You found the water. A dead man's name has no business on your deed." She stood up. She was not a small woman. She stood straight, and she looked at him directly, and whatever she was feeling she held with the same discipline she had applied to holding the paper. "I intend to repay you," she said. "Worry about December 2nd, Harlan said. He waited while she gathered her bag. He walked with her to the bottom of the Gurley Street stairs and watched until she had climbed them and knocked and been admitted. Then he checked the time. It was 10:38, and walked toward Judge Edmonds's office. The meeting with Edmonds on the Verde Valley matter took 40 minutes, which left Harlan a quarter hour with the judge after the official business concluded. He used it. He laid out the Voss situation in the same terms he had given Waverly: the original filing, the false marriage record, the timing, Marsh's involvement, Cray's company. Judge Alexander Edmonds had been on the Yavapai County bench for 6 years. He was not a corruptible man, but he was a careful one. Careful in the sense that he did not move faster than the evidence required, which was a reasonable quality in a judge, but occasionally a frustrating one in a territory where the evidence had a way of disappearing before the motion was filed. "Waverly is filing today," Harlan told him. Edmonds looked at the clock. "Today? Before closing. You'll have his letter within the hour." Edmonds nodded slowly. "If Waverly's filings are in order, and the Bexar County documentation confirms the forgery, I can require the recorder's office to suspend the estate proceeding pending my review. That would stop Cray's claim from advancing while the fraud question is open." "That's what I'm asking," Harlan said. "You're asking for my attention on a land dispute that is technically outside your jurisdiction and apparently funded by your personal bank account," Edmonds observed. "I'm asking you to do your job before December 2nd, Harlan said, without edge. Edmonds looked at him for a moment and then made a sound that was not quite a laugh. "Send me Waverly's letter." Harlan left the courthouse and walked back toward Gurley Street. He stopped at the land office on the way and found the first clerk, whose name was Dennison, and told him what he had observed that morning. Dennison had the look of a man who had been waiting for someone to say this aloud. Harlan told him that Waverly's filings would arrive before closing, and that it would be useful for the office to have the original claim file pulled and ready for review when they did. Dennison said he would pull the file. He also told Dennison that Gilbert Marsh's query, the one that had initiated the re-recording, should be examined to determine under what authority it had been made, since land agents did not typically have standing to query existing homestead claims without a specific basis. Dennison wrote something on a piece of paper without being asked to. The amount was not in question. The question was whether any of it would hold. It held. Waverly's filings reached the recorder's office at 4:40 in the afternoon of October 9th, 40 minutes before closing, which was tight enough that the receiving clerk, a man named Dobbins, had clearly hoped they would not arrive in time. Dobbins recorded them anyway, because Waverly had sent a copy of the same filing directly to Judge Edmonds's office by hand, and a filing that the judge had already received was not a filing that a county clerk could choose not to record. Dobbins recorded them. Waverly's letter to Edmonds arrived at the courthouse at 11:10. Edmonds read it that afternoon. He signed a suspension order on the Skull Valley estate proceeding the following morning, October 10th, citing an open question of fraudulent document provenance that required resolution before any estate claim could advance. The order was served on the Skull Valley Land and Grazing Company at their registered address, which was, in practical terms, Alderman Cray's office in a brick building 2 streets from the courthouse, at 2 o'clock in the afternoon. Cray responded through his attorney 4 days later, opposing the suspension and demanding that the matter be heard on an expedited schedule. Edmonds set a hearing for November 14th. The Bexar County documentation was the critical element, and it arrived on November 3rd. Waverly had telegraphed the Bexar County Clerk's office the same afternoon he made his Prescott filings, requesting a certified copy of the original registration ledger for November 1879 and a notarized statement from the clerk on duty at the time of registration. The Bexar County Clerk's office, a different clerk from the one who had been in office in 1879, which helped, had searched the ledger and found the registration. It was in a different handwriting from the surrounding entries, on a page that showed evidence of a single addition to an otherwise continuous record, dated in a way that did not match the sequence of other entries recorded that week. It was, in the language of the clerk's notarized statement, an anomalous entry of uncertain provenance. Waverly presented this at the November 14th hearing, along with the original filing receipt from the Prescott Land Office, showing Delia Constance Meter as sole claimant on March 8, 1881, along with her sworn statement that she had never contracted a marriage with Reuben Henry Voss or any other person, along with two sworn statements from men who had been in the Prescott Land Office in March of 1881 and had witnessed her filing. Waverly had found them through Dennison, who had pulled the original file as instructed, and discovered two witness signatures on the filing paperwork. Cray's attorney argued that the Bexar County record was a properly filed public record and could not be set aside on the basis of a clerk's opinion about handwriting. Edmonds asked the attorney whether the company wished to produce Reuben Voss to confirm the marriage. The attorney noted that Voss was deceased. Edmonds said that was a complication. He issued his ruling from the bench at the end of the hearing. The estate proceeding for the claim of Reuben Henry Voss in the matter of the Skull Valley parcel was dismissed for lack of standing, on the grounds that the marriage record upon which the re-recording was based was of uncertain provenance and insufficient to override the original claimant's documented entry. The recorder's office was directed to correct the deed to reflect the original sole claimant, Delia Constance Voss, née Meter. The recorder's office made the correction on November 21, 1883. The corrected deed was in Delia's hands on November 23rd. She held it in the land office, a different chair, a different clerk, but the same pine counter and the same territorial seal on the plaster wall, and read her own name on it, and then set it down carefully and sat for a moment with her hands in her lap. Nobody in that room made a sound. She had been told by Waverly that Harlan had returned to the Tonto Basin the morning after their first meeting, which was the 10th of October. He had not been in Prescott for the hearing on the 14th of November. Waverly had represented her interest competently and completely. The correction had proceeded without Harlan's presence, because he had done what needed to be done before he left. He had put the mechanism in motion, funded its operation, and given it enough institutional attention, the judge, the clerk, the letter, that it had enough momentum to reach completion on its own. Delia asked Waverly for Harlan's address. Waverly gave her a post office location in Rimrock, in the Tonto Basin, which was as specific as anyone could be. She wrote him a letter that evening and sent it with the stage the following morning. She told him what had happened. She told him what she intended to do. She told him the amount she owed him and that she would repay it from the spring wheat sale if the winter held decent. She told him one other thing, which was that she wanted him to know she understood exactly what he had done and exactly what it had cost him, and that she would not diminish it by pretending he had done something small. Whether Harlan received the letter is not recorded. No reply was found in any document that has survived. What is recorded is the corrected deed, dated November 21, 1883, in the Yavapai County Recorder's Office Ledger, Book 7, page 214, with the name Delia Constance Voss as sole claimant. That was all she needed it to say. She drove the stage road back to Skull Valley 2 days after receiving the deed, arriving home on the evening of November 25th. The Seep spring was running well. The winter wheat she had planted in September was 4 inches out of the ground in the south field, a dark green band across the pale desert floor that she could see from the road a quarter-mile out. The 9 head of cattle were where she had left them. The adobe structure was cold but sound. She lit the fire and made coffee and sat at the table with the deed in front of her, and the coffee cooling beside it. The fire took hold in the chimney and the room began to warm, and outside the November wind moved through the desert grass with the sound it always made, which was a sound she had learned in the first weeks of her time here, and which was, by now, as familiar as anything she had known. She slept that night without dreaming. By the spring of 1885, the Skull Valley claim had developed into something that could be called, without exaggeration, a working small ranch. The winter of 1883 to 1884 had been a good one, not wet enough to cause problems, wet enough to give the wheat its full season, and Delia's March 1884 harvest at the South Field had yielded 41 bushels, which she sold to the Prescott provisioner at 90 cents a bushel for a return of $36.90. That alone did not repay Harlan's $287, but it was a beginning. She had expanded the cattle herd to 17 head by April of 1884, purchasing 8 additional animals from the same Holbrook operation that had sold her the original 12, and by the autumn of that year, she was running a small but consistent operation on the South Grassland. The seep spring had been improved. She had hired Ernesto again for a 2-week engagement in the summer of 1884 to excavate a proper basin around the spring's outlet and channel it into a holding tank she had ordered from a Prescott metalworks. The tank held 300 gallons, which was sufficient for the cattle and the household and a reserve against dry months. She had also, in January of 1885, sent a bank draft to F.P. Waverly's office with instructions to forward it to Cole Harlan at the Rimrock address. The draft was for $287, the full amount Harlan had spent on fees, not a cent more or less. Waverly's letter back to her, dated February 3, 1885, confirmed that the draft had been forwarded. Whether Harlan cashed it, Waverly could not say. He had sent it as instructed. One morning in the spring of 1885, a young woman named Agnes Tillman, who had taken up a homestead claim 8 miles north of Delia's on the same Skull Valley Road, came to the claim on foot, which was how she traveled, and sat at Delia's table and drank coffee, and told her what she had learned about filing a proper entry and what she needed to know before she went to the Prescott Land Office. Agnes Tillman was 23, from Missouri, unmarried, and she had come to the territory with the same research Delia had conducted 4 years earlier. She knew about the Homestead Act's provisions for single women. She did not know about the additional precautions. Delia told her. She told her about keeping a copy of the original filing receipt separate from the claim documents and in a different location. She told her about confirming with the recorder's office annually that the deed remained in the correct name. She told her to put her full legal name, every part of it, on every document she signed in connection with the land, and to note any discrepancy between documents immediately in writing to the recorder's office and to the land office both. She told her one other thing. She told her that if she ever found her claim had been re-recorded in another name for reasons she had not authorized, there was an office in Prescott where a woman could go, and a judge named Edmonds who took fraud seriously. Agnes Tillman listened. She wrote some of what Delia said in a small notebook she carried. She thanked her and walked back north along the road. She filed her entry the following week and filed it correctly. She stayed on her claim for 11 years. Gilbert Marsh resigned from the Prescott Land Agency in February of 1884, citing health. He moved to California and is not recorded in Arizona Territory after that date. Alderman Cray continued his land consolidation operation in Yavapai County for 3 more years, but the Skull Valley Land and Grazing Company dissolved in 1887. Its remaining holdings absorbed into a larger Phoenix area operation that was itself eventually absorbed into the cattle operations that dominated the territory's economy through the turn of the century. Cray's name does not appear in connection with the Skull Valley parcel after Edmonds's November 1884 ruling. The Seep Spring, it turned out, was not the modest water source it had appeared. In 1888, a Prescott survey conducted for a proposed stage road extension identified 3 secondary springs in the northeast corner of Delia's parcel that fed the same underground system as her original seep. Properly developed, the water system could support 5 times the cattle she was running. She developed it carefully over the next 6 years, not because she was in a hurry, but because the land rewarded patience at the ratio she had always calculated. Cole Harlan continued as marshal of the Tonto Basin through 1891, at which point the Territorial Marshal's Service reorganized its jurisdictional boundaries, and Harlan retired from official service at 53. He remained in Rimrock, in the Tonto Basin, on the small property he had maintained there. He was consulted informally by the successor marshal on a number of cases through the middle 1890s, because there was country in the eastern basin that the new man had not yet learned to read. Harlan taught him what he knew in the manner he had always used, which was by moving through the country and letting the country explain itself to someone paying attention. He died in the autumn of 1901, at the age of 63, at his property in Rimrock, of a cardiac event that had been coming for several years. He was buried on the property at his own request, under a juniper he had planted the year he took the marshalling job and which was, by 1901, large enough to provide genuine shade in summer. The Tonto Basin settlement that grew around Rimrock held a small service for him attended by 23 people, most of them ranchers and freighters, and their families. The presiding minister, a circuit preacher named Harlow, said that Harlan had been a man who understood the difference between law and justice and had spent 20 years trying to close the gap between them in a territory where the gap was wide. The bank draft that Delia had sent him in February of 1885, $287, was found uncashed in his desk drawer when his effects were sorted after his death. It was still in the envelope Waverly had addressed to him. The envelope had been opened. The draft was inside. It had never been presented to a bank. By the summer of 1921, the property that Delia Constance Voss had filed on in March of 1881 was running 64 head of cattle on a developed water system that served 400 acres, the original homestead parcel having been expanded 3 times through legal purchase, at prices Delia had negotiated personally. She had never sold the land. She had never left it for more than the time required to conduct business in Prescott, or once, a trip to visit her sister Marguerite in San Antonio in 1897, from which she returned after 11 days with the same efficiency she had applied to everything else in her adult life. She ran the ranch until 1914, at which point she transferred operational management to her nephew, Marguerite's younger son, James Voss, who had come to the territory in 1909 at her invitation, and whom she had spent 4 years teaching the specific knowledge required to operate in this particular piece of country. She retained the deed. She retained the title. She continued to live on the property in the adobe structure that had been expanded twice from its original single-room design, and she continued to ride the perimeter on a horse she replaced every decade with an animal of similar temperament, which was to say patient and deliberate, and harder than the animal looked. She died in July of 1929, at the age of 73, at the property, in the room where she had slept on the first night she arrived home with the corrected deed. She had given instructions about her estate in writing to James Voss 4 years before her death, and those instructions were clear enough that no dispute arose among her heirs. The land passed intact. James Voss's daughter, a woman named Ruth who had been born on the property in 1912 and who therefore had never known it as anything other than theirs, hung the original 1883 deed on the wall of the expanded adobe structure in 1931. It was the corrected deed, the one dated November 21st, 1883, with Delia Constance Voss as sole claimant, framed behind glass, because Ruth had learned from her father what the deed represented, and she understood that a document that had survived that particular route from filing to correction to delivery deserved more protection than a drawer. The frame hung on that wall for 48 years. In the spring of 1979, a Prescott journalist named Carl Ames, who was writing a history of Yavapai County land disputes, came to the property, which was still operating as a cattle ranch, under the management of Ruth's son, a man named Gerald Voss, who was 61 and who had been running the place since 1953. Ames was researching the Edmonds era on the county bench and had found the November 1884 ruling in the courthouse records, which referenced the Skull Valley parcel and the fraud claim against the marriage record. He had traced the parcel forward through the records and arrived at Gerald Voss's door with a notebook and a tape recorder, and the question of whether anyone in the family had documentation about how the original 1883 challenge had been prepared. Gerald Voss took him inside and showed him the framed deed on the wall. Then he took him to the desk in the back room, which had been Delia's desk, and which had remained in the house through all the subsequent years, and he opened the bottom right drawer and showed him what was inside, a collection of documents, each in its own envelope, arranged in order of date. The original filing receipt from March 1881, the recorder's re-recording letter from August 1882, the Bexar County Clerk's notarized statement, Waverly's copies of his own filings, Judge Edmonds's ruling, and at the back of the drawer a letter written in a hand that was not Delia's, a precise, spare hand, the kind used by a person who had learned to write functionally rather than decoratively, addressed to no one in particular, on a single page, apparently placed in the drawer at some point after the ruling. The letter said, in its entirety, "The land is yours. You built it. That is enough." It was not signed, but Gerald Voss knew whose hand it was. His grandmother had told his father, who had told him, that a marshal named Cole Harlan had walked into the Prescott land office on an October morning in 1883 and asked one question, and then gone out and fixed what was broken, and that she had never been able to explain, in all the years she thought about it, what had made him stop. The journalist Carl Ames asked Gerald Voss whether the family had ever looked into Harlan's background, what else he had done, whether there were other cases like this one. Gerald Voss said they had not looked particularly. He said his grandmother had said something on the subject once, when James Voss had asked her the same question in her last years. She had said that she thought a man who does a thing like that once has probably done it before and probably will do it again, and that the details were his own business. What was her business was the deed on the wall. She had kept the deed. She had kept the letter. That was the accounting she gave of what she owed him, and she made it honestly, not by diminishing what he had done, but by staying on the land he had helped her keep.